not just verbally, but through imagery and in the open field. And it becomes sort of a norm before we, the organized community, and people in all sectors in our society wake up to the fact that this is going unchecked and has gone unchecked for far too long. The Jewish Federation of Winnipeg is the umbrella organization of the Jewish community in Winnipeg, and we are extremely proud to be a strong ally and partner of the Jewish Heritage Center in Western Canada. We provide support through the generous donations of the Combined Jewish Appeal campaign, and because of that support, we're able to partner in many initiatives such as the adoption of the IRA definition and representing the interests of the Jewish community and the community at large with all levels of government. We look forward to working with the Jewish Heritage Center on the education program on Holocaust education this November. I'd like to thank the Switzer family for establishing this wonderful prize, for expanding our knowledge of the Jewish history of Western Canada. More specifically, I'd like to congratulate the award winner, and we will hear more about that. But at this time, my sincere appreciation for all of the hard work and the incredible amount of curation and content that resides within our very own Jewish Heritage Center of Western Canada right here in Winnipeg. Once again, good evening, and I look forward to learning together with all of you.
Thank you, Gustavo, for your wonderful work. And now it's my great pleasure to introduce Paul Switzer, representing the Switzer family. The Switzer family has established the Switzer-Cooperstock Prize, which was inaugurated in 2008, for essays, the best essay on Jewish history in Western Canada. Several years ago, we broadened it, the Switzer family broadened it to include a student prize, and today's paper will be the second prize in this in the student category. Professor Paul Switzer comes from Winnipeg, where he attended St. John's Tech and the University of Manitoba before going to Harvard for graduate work. He has a very distinguished career at Stanford University, where he is now Professor Emeritus of Statistics. He has done a great deal of work on environmental issues. Professor Switzer has held visiting professorships around the world, including France, Italy, Japan, and many other countries. He has initiated the Switzer-Cooperstock Lectureship. Tonight we hear the winner of the Student Prize, and next year, like last year, the winner of the Senior Prize will present a paper. Paul, would you please tell us something about the Switzer-Cooperstock family and the prize, and please go ahead.
Yeah, thanks, Dan. And first of all, I'd like to congratulate Kenneth Grad, the recipient of this year's Student Prize. I'm looking forward very much to his lecture today. I also want to thank the staff of the Jewish Heritage Center, who over the years have contributed so much effort and good work to in the gathering together of the recipients of these prizes over the years. And I'd like to call in particular Dan and also Bill and Stan Carboni. I'd also like to thank the jury members who select the recipients of the prize, because they do a lot of hard work each year that the prize is awarded. So this lecture honors the memory of Rose Cooperstock Switzer, my mother, and Louis Switzer, my father. They immigrated separately to Manitoba in the early 20th century. And they were wonderful parents to me and my brother Fred. Their immigration to Canada, like many Jews, was spurred by the special hardships that were endured by the Jews of Europe. And I'd like to mention in particular that Louis, my father, as a boy of 10 years old, was a witness to the anti-Jewish pogroms of 1919 that his shtetl Sudilkov experienced at the time. Of course, much worse was to come some 20 years later at the hands of the Nazis, who murdered the remaining population of the shtetl and many of the other shtetls in Ukraine. And among the victims was my father's brother and his young family. Sadly, anti-Jewish sort of like hatred was visited once again in Manitoba and Canada during the 1930s, where there's a period of vicious anti-Jewish propaganda. And I can imagine how it must have felt for the largely immigrant communities at the time to have immigrated and then have to see and hear this awful stuff that was still coming out, anti-Jewish stuff. But we'll hear today how that played out, and I'm very interested to hear. And in particular, I think we're going to hear about the very brave Jewish lawyer that period, Marcus Hyman. Now I'd like to return it back to Dan Still.
Thank you, Paul. And once again, thank you to you and the family for establishing this prize, which has been given since 2008 and has illuminated so many areas of Western Canadian Jewish history. Now I'd like to introduce the speaker, Mr. Kenneth Grad, who is a PhD student at Osgoode Hall, a branch of York University. He is specializing in studying cases against Ernest Zundel and James Keekstra for themselves, and also to see how criminal law can be used to fight hate speech and to protect persecuted minorities. Jews, of course, are a persecuted minority often, but there are other persecuted minorities. And so this approach of studying how the law can function is particularly important on a broad scale. Mr. Grad has degrees from the University of Toronto, Queen's University, Osgoode Hall, and Harvard University. He practiced law in Toronto for several years before returning to university to work on a doctorate. He published several articles in academic and non-academic publications. He has won numerous grants and awards, most recently the R. Roy McMurtry Fellowship in Legal History, a very distinguished prize at Osgoode Hall, and also one that helps him continue his studies. Tonight's paper discusses a method of addressing hate speech that came from the Manitoba Jewish community in the 1930s and was enthusiastically supported by the entire community. It's particularly topical, as we've been saying, in view of the rising tide of anti-Semitism and other forms of hate speech in Canada and throughout the world. Following the presentation, there will be a question and answer period. Please put your questions and comments on the Q&A line. That's on the bottom of many computer screens, on the top of some others. And I will read out the questions or comments, and Mr. Grad will respond, or if he's one that he particularly wants to pick out, he'll go ahead with it. The limitations of the webinar form do not permit me to call on you to speak yourselves. I will try to keep an eye on the chat line too, but I'm very likely may miss something. So please use the Q&A line. Now, please, Kenneth, go ahead. We're very much looking forward to your talk.
Good evening, everyone. Thank you very, very much. And my congratulations to you, Justice Cantor, on your recent appointment. Thank you, Gustavo, Professor Switzer, and Professor Stone for that very kind introduction. It's a pleasure to be here, virtually, of course. And I want to begin by thanking the Jewish Heritage Center and the Jewish Federation of Winnipeg for putting on this event and for bestowing this year's Switzer-Cooperstock Student Prize upon me. I am humbled to receive it and privileged to have the opportunity to present my research to you this evening. I particularly want to thank Professor Switzer and the Switzer family for endowing this award and for all their work in supporting research into Manitoba's Jewish history. And last but not least, thank you to all of you for attending this evening. I want to begin as well with a bit of further background about myself, including how I came to the topic that I have the honor of discussing with you today. As Professor Stone noted, I am a lawyer. I'm also an adjunct professor who has practiced criminal law and civil litigation here in Toronto. I'm currently pursuing a doctorate at Osgoode Hall Law School, where I also teach criminal law. The focus of my dissertation is on the use of the criminal law to combat hate speech. And as Professor Stone noted, more particularly, I'm writing a history of the prosecutions of Ert Zundel and James Keekstra from the perspective of the Jewish community. No doubt many of you are familiar with and perhaps recall these cases. An important component of my research is the trauma that criminal trials, and especially these two criminal trials, the Zundel and Keekstra trials, may visit on victim communities. And so you might be wondering, how did this background lead to my writing an article on Manitoba legislation, and specifically pre-Manitoba Jewish history? Well, I can tell you that it did so in two primary ways. First, as part of my doctoral research, I have written about the origins of our hate speech legislation in the Criminal Code of Canada. I'll have a bit more to say about that legislation in a moment. And in conducting this research in the archives, I came across an earlier effort in Manitoba prior to World War II to deal with hate speech that I had never heard of and regarding which I had not seen much written about. Accordingly, I decided to look into it more and was fascinated by what I found. I subsequently published the article on this topic that I am presenting today in volume 33 of the journal Canadian Jewish Studies. And the second very important factor with respect to my background that inspired me to write about the Marcus Hyman Act was the fact that about 4 years ago, I married my wife, Arlie Rosenberg, who is from Winnipeg. Since meeting Arlie, she and her parents have welcomed me with open arms. I've discovered that they call it Friendly Manitoba for a reason. And I've gotten a crash course on all things Manitoba related. So much so that I've declared myself an honorary Winnipegger. Unfortunately, my status as an honorary Winnipegger is entirely self-proclaimed. It's entirely self-proclaimed. In fact, upon telling my wife that I felt like an honorary Winnipegger, she seemed to disagree and told me I could never hide the fact that I'm from Toronto. But nevertheless, I continue to insist that I will obtain this esteemed status, and I hope that my research into Manitoba's Jewish history and this evening's lecture will score me some points in this important endeavor. And so with that background in mind, let me turn to the topic under discussion, the Marcus Hyman Act and its historical and contemporary significance as a civil law remedy for hate speech. And so let me begin with a brief outline of my presentation, what I intend to cover today. I'll begin with an overview of the historical events under discussion, sort of a bird's eye view of the history that I will be talking about in a bit more detail. And I'll then turn to a short overview of our current legal landscape when it comes to hate speech, focusing on what the criminal law and non-criminal law has to say about remedies for harmful speech. Following which, I'll take you in detail through the core component of my article, which is the historical background of the Hyman Act. And I'll then take up what I think is the Hyman Act's contemporary significance and current relevance in light of our current climate. And I hope we can then conclude by engaging in a bit of discussion on these important topics. So before turning to my topic in more detail, I wanted to just go over in broad strokes the history that I'll be canvassing. And the story of the Marcus Hyman Act, it really picks up in the early 1930s, particularly in 1933 after Hitler's ascension to power in Germany. And these worldwide events led to some fascist parties and neo-fascist movements around the world, unfortunately, including the formation of a fascist party in Manitoba called the Canadian Nationalist Party. And that party was headed by a man named William Whitaker. In 1934, this led to the enactment of the Marcus Hyman Act, an act that permitted the Jewish community to sue Whitaker for libel, which is a form of written defamation. And that lawsuit against Whitaker was launched in late 1934 by a man named William Tobias on behalf of the Jewish community. And ultimately it was successful, and the Jewish community obtained an injunction against Whitaker. Now, following this loss and this success against Whitaker, the Canadian Nationalist Party, it really fell into quite a steep decline. But nevertheless, despite this seeming success, the Marcus Hyman Act has actually rarely been used since then, although it remains good law in Manitoba. It remains on the books. And I want to suggest that perhaps it deserves a closer look, particularly in light of our recent climate of rising xenophobia, including anti-Semitism. And so, why do I believe this history is important? Why study the Hyman Act? Well, a primary reason, as I've alluded to in our introductors alluded to as well quite eloquently, is in light of this recent rise in hate speech and hate crime. And probably no one here needs a reminder of this, sadly, but it has really affected Jews and really all minority groups, certainly not just the Jewish people. And to give just one example, according to data released by Statistics Canada in 2023, hate crimes targeting a given religion rose by 67%, so quite a high increase, and those targeting race or ethnicity rose by 6%. And you may have seen that B'nai B'rith does an audit of anti-Semitic incidents year by year, and they note that such incidents have really reached record highs in recent years. They noted a slight dip this year, but really they're continuing to be at record highs, and they really rose quite sharply, especially during the COVID pandemic. Now, this has led to various proposals for new legal approaches to counteract harmful speech, new legal approaches for how we'll deal with this problem. But the focus in these proposals tends to be on the criminal law. It tends to be on the criminal law. Relatively few civil law remedies have been suggested to deal with hate speech. But the criminal law, in my view, and based indeed as well on empirical evidence, has been somewhat ineffective, or at the very least infrequently used. And as a result, I think that we should think about expanding civil law remedies to complement, not necessarily replace criminal law remedies to combat hate speech. And I think the Marcus Hyman Act provides a useful historical example for why these sorts of remedies should have a more prominent place in the law, or at the very least, a place at the table in the recent debate over legal solutions to rising hate speech. And so you may be wondering, what are our existing criminal law remedies in Canada for harmful speech? What kind of laws do we have in our criminal code that deal with hate speech? And there's no one hate speech provision in the criminal code. It's a bit of a mishmash. But the heart of the legislation in Canada, the heart of the criminal legislation, is found in the hate propaganda sections of our criminal code, the hate propaganda sections. And these sections were actually enacted in 1970, largely due to lobbying from the Jewish community. That's something I've written about elsewhere. And prior to 1970, we didn't have criminal legislation specifically targeting hate speech. So this was new legislation enacted in 1970. Now, these provisions, although they weren't used very often originally in the years after their enactment, they have been used increasingly in recent years, but their use is still relatively infrequent. And furthermore, Statistics Canada data shows that conviction rates for these offenses are low compared to other offenses. So there are more acquittals under these charges relative to other offenses, many other offenses in the criminal code. And I want to point you specifically to another provision in the criminal code that was recently enacted just last year to combat the willful promotion of anti-Semitism. And specifically, it combats the willful promotion of anti-Semitism by denying the Holocaust. So effectively, Canada has made Holocaust denial a crime. And this is something very recent. It was introduced only last year. And note also, something you may have heard about is our former Section 181. This statute prohibited the spreading of false news, something called the spreading of false news. And you may have heard of it because this was the provision that was used to prosecute Ernst Zundel. Unfortunately, or fortunately, depending on your perspective on these issues, the Supreme Court struck down the false news provision when the Zundel case reached our highest court, the Supreme Court of Canada, in 1992. They said it was an unconstitutional infringement on freedom of speech. In contrast, our Supreme Court upheld the constitutionality of our other hate propaganda provisions in the criminal code when they considered those provisions in the Keepster case. So our other hate propaganda provisions, those outline willful promotion of hatred, they have been deemed constitutional. Now, so that's our criminal law, but there are some other legal mechanisms elsewhere at our disposal to combat harmful speech. And many of these may be found in what's called human rights legislation. Human rights legislation is legislation generally passed by individual provinces or by the federal government that sometimes offers an avenue for the state to bring a proceeding against someone who promotes racism and or hate speech. But only a few provinces, as well as the Northwest Territories, contain such provisions in their human rights legislation. So provisions that would permit the state to bring a human rights proceeding against someone who is promoting hate speech. And notably, Manitoba is not one of them. Manitoba is not one of the provinces that has such a provision. Now, historically, there was also a provision in our Federal Human Rights Act that prohibited a person from communicating either by telephone or over the internet in a manner likely to expose a member of an identifiable group to hatred or contempt. But in 2013, this provision was repealed by the Harper government. Now, the Trudeau government tabled a bill a couple of years ago that would have reintroduced a similar provision, but it was not passed. The government was dissolved and ultimately has not been taken up again. Now, aside from the criminal code and human rights legislation, which are both examples of public law, so that they're law that emanates from the state, there are precious few private law remedies available to combat hate speech. And what I mean by that is there are very limited options if someone wants to sue a person, to bring a lawsuit against a person for defaming an entire group of people. The reason for this is that our law generally does not accept group defamation as a legitimate cause of action. Our law does not accept group defamation as a legitimate cause of action. What does that mean? It means that if one defames an entire group of people rather than an individual, you cannot sue them for this. And if I can illustrate by way of an example, if someone said that all fans of the Toronto Maple Leafs are fair weather fans who are living off of past glory and haven't won anything meaningful since 1967, that could not give rise to a defamation suit because it involves an allegation against an entire group of people. But anyways, I don't need to tell anyone here, that type of accusation about Maple Leaf fans would also be subject to the defense of truth. Now, if, however, any individual person is defamed, that, as you well know, could give rise to an individual lawsuit. You can sue someone who defames you as an individual, but you have to show some personal harm. So the default rule, unless changed by statutes, unless a legislature changes the default common law rule, the rule is that you cannot bring a lawsuit for group defamation. You can only bring a lawsuit for personal defamation. Now, the only exception, there's one exception to this general rule, that you can't bring a lawsuit for group defamation. And that exception is found in Manitoba. Manitoba, in fact, has provincial legislation that specifically authorizes lawsuits for group defamation. And that can be found in Section 19 of Manitoba's Defamation Act. Specifically, what the law says is that the publisher of a libel against a race, religion, or sexual orientation likely to expose persons belonging to that race, religion, or sexual orientation to hatred, contempt, or ridicule, and tending to raise unrest or disorder among the people, may be sued in the Manitoba Court of King's Bench. That's what this provision tells us. And note that the only remedy permitted under the legislation, so the only remedy that's authorized by this provision, is an injunction. So you can obtain an injunction against the hate monger, sort of a court order that dictates they must stop with the libel, rather than monetary damages. The permitted award is an injunction. And note as well that libel, as I mentioned, refers to written defamation. So this covers written rather than oral defamation, which we refer to as libel. So that's the law in Manitoba. And as I said, this is unique to Manitoba. But how did Manitoba get this law? Why is this legislation on the books of Manitoba and nowhere else? And that's really the heart of what my article explores, and what I think is a fascinating part of Manitoba's Jewish history, and something the Jewish community should really take pride in. And the story of this legislation really commences in July of 1933, when a man named William Whitaker, inspired by the rise of Hitler in Germany, decided to create a fascist party in Winnipeg. And he called it the Canadian Nationalist Party. Now, at the time, Manitoba had about 20,000 Jews, quite a strong community. It was becoming more politically active. As Professor Switzer noted, much of it consisted of recent arrivals to Canada. And this development, Hitler's ascension, of course, but also the creation of the Canadian Nationalist Party, put that community on edge. It put that community really on edge. And that was particularly so when Whitaker and his followers began holding rallies and posting anti-Semitic bulletins in and around Winnipeg. Now, what particularly angered and concerned the Jewish community was when, in November of 1933, Whitaker began publishing a monthly newspaper, which he called the Canadian Nationalist. And Whitaker and his followers brazenly distributed this newspaper on the streets of Winnipeg and circulated it throughout the province. It's really tough to know how broad the circulation was of this publication, but we do have some evidence, some anecdotal evidence, suggesting that it did circulate quite widely in the province, including many smaller municipalities outside of Winnipeg. Now, to refer to this as a journalistic endeavor is obviously to give it a credit that it does not deserve. It basically consisted of a mixture of diatribes and repackaged anti-Semitic tropes and the reprinting of anti-Semitic text, such as the Protocols of the Elders of Zion. Now, as Whitaker's party seemingly gained strength, it continued to seemingly gain strength, moving through 1933 into early 1934, continued to hold rallies and distribute the Canadian Nationalist. And again, the Jewish community was quite on edge. And one response to this was quite visceral, quite a visceral response to the formation of the Nationalist Party. In early 1934, an anti-fascist league was formed in Winnipeg, consisting of largely of Jewish members, but also non-Jewish members, many of whom were young and active in the Communist Party. And also in early 1934, two young Jewish men affiliated with this movement, named Isaac Kettner and Boris Weller, they assaulted a member of the Canadian Nationalist Party who had been selling the Canadian Nationalist on a street corner in downtown Winnipeg. The man who was selling the newspaper had apparently provoked the two young Jewish men by telling them that it was the goal of the Canadian Nationalist Party to drive all Jews out of Canada, and that they would soon be driven out of Canada too. Now, although Kettner and Weller were arrested and charged with robbery, they were defended by M.J. Finkelstein, who was a prominent lawyer and president of the Canadian Jewish Congress's Western Division. And thanks in part to his defense, they were acquitted at trial. And the Jewish community was particularly pleased when the trial judge remarked that he was acquitting the two young Jewish men because, in the trial judge's view, the contents of the Canadian Nationalists were disgusting and libelous of the Jewish people. Now, despite this positive outcome, this type of vigilante justice, it did not sit well with communal leaders. It really did not sit well with communal leaders, including some prominent rabbis and members of the Canadian Jewish Congress who were disturbed by this type of violent conduct, and they feared further violence in the future. But these communal leaders were more supportive, however, of a legislative approach advanced by a member of the Manitoba Legislative Assembly, a man named Marcus Hyman. And by way of background, I should tell you that at this time, Manitoba's legislature consisted of three parties. It had three parties at the time. It had the ruling Liberal Progressives, who were led by Premier John Bracken, and they held 38 seats, which gave them a large majority in the legislature. The Conservative Party held 10 seats, and then the Independent Labour Party, which benefited from considerable support in the Jewish community. The Jewish community at the time tended to support the Independent Labour Party. It was the precursor of the CCF and later the NDP. That party held only 5 seats. One of these members was Marcus Hyman. He was a member of the Independent Labour Party. Now, Hyman was originally from England, and he had earned his law degree from Oxford before spending a brief amount of time in India before moving to Winnipeg in 1913. He became, upon arrival in Winnipeg, a very successful labor lawyer, and his work actually included defending persons charged during the 1919 Winnipeg General Strike. Now, Hyman won a seat to the Manitoba legislature in 1932 as a member of the Independent Labour Party, and he became a very well-respected member of the legislature. In fact, the Winnipeg Tribune, their parliamentary reporter, he commented that Hyman combined with a pleasant voice and cultured diction the laudable qualities of forcefulness and brevity, even though the reporter also admitted to sometimes finding it difficult to ascertain exactly what Mr. Hyman was trying to convey. And so in March of 1934, Hyman introduced an act in the legislature specifically to target Whitaker and the Canadian Nationalist newspaper. Now, that bill, in fact, was drafted by a man named Ernest Brotman, who was a lawyer who had previously worked for Hyman in private practice. So you can see that the Jewish community was really involved with this effort behind the scenes. And the act was in substance, the bill that was introduced by Hyman was in substance the legislation that we saw earlier, and that is still contained in Manitoba's Defamation Act. Although Hyman's version, it did not contain reference to sexual orientation. That was something that was added later. Now, Hyman's bill, it was designed to amend the law to permit Whitaker and others to be sued for libeling an entire class of people, in this case, Jews. And in fact, it was really drafted with Whitaker in mind. And note that in addition to the libelous nature of the speech, the language of the bill provided that the speech had to be of a form tending to raise unrest or disorder among the people. So that was an additional requirement, this requirement that it had to raise unrest or disorder. It was included by Hyman to overcome concerns over freedom of speech. And note as well that Hyman's bill allowed only for an injunction, as I've mentioned, only for an injunction against the person being sued, not damages, not monetary damages. And this was specifically because, as Hyman later explained, he felt that in order to get the bill passed, he had to make clear that the Jewish community was not looking for any monetary gain, that the Jewish community was not looking to profit off of the legislation. They simply wanted this type of hate speech to stop. Now, what's really remarkable, one of the things that's really remarkable about this bill introduced by Hyman is that it passed unanimously in the Manitoba legislature, quite quickly, in fact, and with the full support of all parties, including John Bracken's government. Even though, recall that the Independent Labour Party only had 5 seats in the legislature. And what's notable as well in this regard, what's notable as well in the fact that it was passed with unanimous support and quite quickly in Manitoba, is that similar efforts in Ontario and Quebec around the same time failed miserably. So there were similar efforts around the same time introduced by Jewish legislators in Ontario and in Quebec to enact similar legislation that would provide an outlet for a lawsuit for group defamation. And though both of those bills failed quite miserably, and in Quebec, in fact, the government ultimately turned against the bill, and this raised anti-Semitism in Quebec to new heights. So why did Hyman's bill fare better? And I suggest this was for a couple of reasons. Firstly, Manitoba, I think it's fair to say, was really more hostile to fascism, perhaps than some other provinces. For example, the Winnipeg Free Press, under the editorship of John W. Defoe, at the time took an early and very strong stance against Nazism. And the Manitoba media generally responded positively, or at least indifferently, to Hyman's bill. There was no sort of a backlash in the media as we saw in Quebec and in Ontario in response to similar legislative endeavors. And I think the second reason why Hyman was successful was really because of his esteemed reputation and his cautious approach to the legislation to build up a broad base of support and thereby ensure passage of his bill. So the bill was passed, but despite the unanimous passage of the Hyman Act in April 1934, Whitaker, unfortunately, he seemed initially undeterred. He really seemed undeterred. And he continued to hold rallies and circulate his newspaper. And in fact, in a sense, seemed to even be growing bolder. Now, on June 5th, 1934, matters really came to a head in Winnipeg's Market Square. Some of you may have heard of this, that it was a famous incident in Market Square on June 5th of 1934, when Whitaker was attempting to hold a rally in Market Square with about 75 of his followers, whereupon they were met by several hundred communists, including members of the Anti-Fascist League. And Whitaker and his hopelessly outnumbered followers were, as the Winnipeg Free Press described, beaten unmercifully. But despite this beating, Whitaker, he carried on. He still carried on, and his newspaper continued to circulate. And the Jewish community continued to be concerned. Accordingly, Jewish community leaders met behind the scenes, and they decided that they would deploy their new legal weapon, the Marcus Hyman Act, by launching a lawsuit against William Whitaker. And so Jewish lawyers worked together to craft the legal strategy, to help draft a statement of claim, although ultimately they employed a non-Jewish firm, Andrews, Burbidge, and Bell, as their public face in the lawsuit. So this firm acted as the public face, but Jewish lawyers were working behind the scenes really to craft the legal strategy. And as the plaintiff in the suit, so they needed to choose a plaintiff to bring the lawsuit on behalf of the community, and they decided to choose a man named William Tobias. He was another highly esteemed member of the Jewish community. And the Manitoba-born Tobias, he had actually served in the Canadian military during the First World War and was awarded the Military Cross. So he was a war hero. And he too was a prominent lawyer who had been elected to the Legislative Assembly as a member of the Conservative Party in 1928, although he lost his bid for re-election in 1932. Now, following Tobias's political defeat, he remained a prominent member of the community and was in fact the first president of the General Monash branch for Jewish members of the Canadian Legion. So he remained quite a respected member of the community, both in non-Jewish and both in Jewish and non-Jewish circles. And so in October of 1934, following publication by Whitaker of another volume of his newspaper, so when another volume of his newspaper came out in October of 1934, Tobias filed the statement of claim under the Hyman Act. So statement of claim was filed. And he launched his lawsuit against both Whitaker and something called the Ranschau Publishing Company, whom it was discovered were publishers of the newspaper. They were the ones who actually published it. However, the owners of the publishing company were later dropped from the lawsuit when they agreed not to do any more work with Whitaker and to write a letter of apology to the Jewish community. And so in November of 1934, Tobias proceeded against Whitaker alone, and he succeeded in obtaining an interim injunction against Whitaker. An interim injunction essentially is an interim order preventing Whitaker from publishing any libelous statements about the Jewish community until the conclusion of the trial. Now, Whitaker fought back. He promised to put up a strong defense. He retained counsel, he filed a statement of defense, and in that document, he asserted that his writings were of great public interest and in any event that they were true. And in December of 1934, Whitaker was forced to sit for an examination for discovery. So in other words, a deposition. He was forced to sit for questioning under oath by Tobias's lawyers. However, upon questioning Whitaker, he refused to answer most of the questions that were asked of him. He basically refused to participate. And so Tobias's attorneys, they went to court once again, and they obtained a court order forcing Whitaker to sit for a deposition and to answer the questions that he had tried to avoid. Whitaker, however, he failed to show up on the appointed date. He did not show up, and thereafter, he stopped participating in the lawsuit. He stopped participating entirely, and it essentially fell out of view. And so with Whitaker basically out of the picture, Tobias's legal victory was essentially assured. In February of 1935, he obtained a permanent injunction. So the injunction became permanent against Whitaker, ending the case. And the language of the injunction was very broad. It prohibited Whitaker not only from publishing the libels contained in the October 1934 edition of the Canadian Nationalist. Recall, that was the subject of the lawsuit. But it also prohibited Whitaker from publishing any similar libels injuriously affecting the Jewish community. So quite broad language, any similar libels. And in awarding the injunction, Justice P.J. Montague commented that he had awarded the permanent injunction unhesitatingly, and he hoped that it would have a salutary effect. Now, so despite this legal victory against Whitaker, historians who have mentioned the Hyman Act before have tended, in my view, to refer to it as somewhat of a hollow victory or a merely symbolic victory. And this is primarily because the Tobias lawsuit against Whitaker did not completely destroy Whitaker's organization. And moreover, Whitaker eventually recommenced printing the Canadian Nationalist. A central argument of my article is that I believe the Hyman Act deserves greater recognition as an important historical moment for Manitoba's Jews. I say this for two main reasons. First, the Jewish community at the time clearly viewed it as a significant victory and was delighted with its success, thereby bolstering the social inclusion felt by the Jewish community during a very difficult time for Canada's Jews. Members of the Jewish community in Manitoba really celebrated their victory in this lawsuit, with Winnipeg's Yiddish newspaper, Das Jiddische Wort, to just give one example. They called it the verdict very important for the people of Manitoba. But this reaction was not limited to Manitoba. The National Canadian Jewish Congress took note of the legal victory over Whitaker and tried to have similar legislation passed in other provinces and even at the national level. And in fact, they even suggested to Jewish leaders in other jurisdictions and other countries that they should consider a similar approach, that they should really consider adopting analogous legislation. In fact, I found a letter in the archives from H.M. Kaiserman, who at the time was General Secretary of the Canadian Jewish Congress. He wrote to South African Jewish officials urging them to follow Hyman's model, telling them of Hyman's success, which he assumed they were already aware of, and urging them to follow Hyman's lead. And Manitoba's success was also written about and circulated in American Jewish circles as well. So news of this success really spread far and wide and helped to bolster the spirit of Canadian and even non-Canadian Jews at a very difficult time. Now, the second reason why I argue that the Hyman Act and the Tobias lawsuit were important victories for Manitoba's Jews is because of the damage inflicted on Whitaker. While it may not have knocked him out, but it was a blow from which he never really recovered. Indeed, in the immediate period after he stopped participating in the lawsuit, Whitaker, he really disappears from the scene, so much so that in March of 1935, the Canadian Jewish Congress used an intermediary, someone who posed as a supporter, someone who was interested in learning more about the Canadian Nationalist Party, to write to Whitaker just to see what he was up to. And Whitaker responded by explaining that he and his followers had really fallen on hard times. And he complained that the power of Jewry had managed to muzzle him in Manitoba. And Whitaker also, for the time being, very importantly, he stopped publishing his newspaper, which was a primary objective of the lawsuit in the first place. Now, moreover, although Whitaker resumed publication of the Canadian Nationalist in late 1935, he was prevented from circulating it in Manitoba. He could only do so out of province. And recall that Whitaker had lost his printer. Remember, his printer had essentially said he would do no work with Whitaker again. And accordingly, Whitaker was forced to publish his newspaper using a mimeograph machine. So essentially, this led to an amateurish quality of the newspaper and undoubtedly limited the scope of his distribution. Furthermore, Whitaker, he never regained the prominence that he had achieved prior to the Tobias lawsuit. Even Whitaker's subsequent announcement in March of 1938. So in March of 1938, Whitaker announced that he had joined with Quebec fascist leader Adrien Arcand and Ontario fascist leader Joseph Carr to form a new party. But even that announcement failed to revive Whitaker's flagging enterprise. In fact, the Yiddish newspaper Das Jiddische Wort basically shrugged off the announcement, informing its leaders that there was no need to take this new-founded party seriously. And the Winnipeg Free Press had a similar reaction, writing an article in which they interviewed Whitaker and then essentially proceeded to mock him pretty unmercifully. Now, Whitaker's finances, as well as his health, continued to decline. And he died really in poverty in October of 1938, and his fascist movement died with him. Now, sadly, Marcus Hyman died soon thereafter too, in December of 1938, and Winnipeg newspapers eulogized him warmly. His funeral was attended by many politicians and dignitaries. And the Winnipeg Tribune commented that Hyman's death had really removed one of Winnipeg's most esteemed figures. And Tobias also passed away quite young in 1941 at the age of 49. And his death too brought an outpouring of grief and adulation in both Jewish and non-Jewish circles. So that's the history. That's the history of the Hyman Act in the Jewish community. But what became of the Hyman Act? What has happened to it since then? It's really scarcely been used since this lawsuit against Whitaker in the 1930s. I could really only find 2 reported cases citing this provision, neither of which involved the Jewish community and neither of which involved clear cases of group defamation. Now, it has also been amended slightly over the years, particularly in 2002, when sexual orientation was added as a prohibited ground of discrimination. Recall that I mentioned earlier that our hate propaganda provisions in the criminal code, in other words, the criminalization of hate speech at the federal level, was enacted in 1970 in large part due to lobbying efforts from the Jewish community. I've published on this elsewhere, and really this push for legislation came from Canadian Jews and particularly Holocaust survivors who were disturbed by neo-Nazi movements that had arisen in the 1960s. Now, members of the Canadian Jewish Congress in Ontario at that time, they considered advocating for a similar provincial law as the Hyman Act. So recall they had tried prior to World War II. Now, post-World War II, they thought about trying again in a more favorable climate to enact a similar legislation to the Hyman Act in Ontario. They consulted their counterparts in Manitoba, but some of their counterparts in Manitoba suggested that a federal law would be preferable because it would prevent the hate monger from simply distributing their material out of province. But Ernest Brotman, recall he drafted the Hyman Bill, he strongly urged the Canadian Jewish Congress to adopt or at least advocate for similar legislation. He argued that the Hyman Act had been successful, and he pointed to its prior efficacy. However, ultimately, the committee formed by the government to study the question of legal remedies for hate speech, which was headed by McGill Law Dean Maxwell Cohen, decided that it would be better to combat hatred through the criminal code. Cohen noted that the Hyman Act, it could be a useful solution. He thought it was a positive endeavor, but he ultimately decided that no civil statute could create a moral standard equivalent to that of the criminal law. And he was also attracted to the idea that the criminal law as federal legislation would apply to the entire country. But as I noted earlier, results under our criminal law have really been mixed. Like what we can say now, essentially a half century after the enactment of our criminal code provisions, is really we've had mixed results with this legislation. In the Keegstra case during the 1980s, which was actually the first successful prosecution under the criminal legislation, Keegstra, he was given a broad platform for his outrageous claims, causing much pain to the Jewish community. And ultimately, after over a decade of litigation, which included 2 criminal trials, although Keegstra's conviction was ultimately upheld, he was given merely a suspended sentence and 200 hours of community service. Certainly, he never disavowed his views. The Zundel trial, similarly, the trial of Ernst Zundel, was a public spectacle and ultimately resulted in Zundel's conviction being overturned by the Supreme Court. In recent years, many have decried the seeming inefficacy of our criminal law and have called for tougher legislation. And this is something that is really brought up all the time. And we've seen an uptick in the number of hate propaganda charges and even an uptick in the number of convictions, but the conviction rate remains lower than other offenses. Note as well that sentences for these crimes are typically not very high. There's a maximum of 2 years incarceration under the legislation, and criminal proceedings, moreover, have really proved costly and very time-consuming. In our search for legal remedies, what is typically absent from the conversation is any focus on private law or civil law remedies. For instance, private lawsuits for group defamation. The history of the Hyman Act teaches us, I believe, that these lawsuits may provide a useful tool to supplement the criminal law. Indeed, such private law remedies have several advantages over criminal law approaches. For one, there's a lower burden of proof in a civil trial. A civil suit must be proven only on what's called a balance of probabilities, which means more likely than not, rather than the much higher criminal standard of proof beyond a reasonable doubt. A second reason why civil law may be preferable is because a private lawsuit may provide less of a platform for the accused than a sensational criminal trial. And certainly we saw that in the Keekstra and Zundel proceedings. Now, thirdly, an important point is that a lawsuit for defamation. In a lawsuit for defamation, the focus is on whether the victim group was harmed. The focus is on harm to the victim group. That's really what's at issue in a private law case. Whereas in a criminal trial, by contrast, the focal point of the trial is typically on the intent of the speaker. The focus is on the intent of the speaker themselves rather than on the victim group. In other words, the focus is typically on whether the speaker willfully intended to promote hatred through their words. And that can be something that is quite difficult to prove. It involves a complicated question of the speaker's intent. And fourthly, a fourth reason why civil law remedies may have advantages is that in terms of our remedies, what remedies can be offered at the conclusion of a trial. The focus of a civil trial in terms of remedies is on making the victim whole. The focus is how do we restore the victim to the position they would have been in but for the harm. The focus is on the victim. But that's different from a criminal trial where the focus, once again, is on the offender. It's on punishing the specific offender. The focus of a criminal trial is not on how to heal the victim. Now, there may be other advantages too. For example, a civil suit may even offer an alternative path into the criminal law. A civil suit may offer an alternative path into the criminal law. So what do I mean by that? I mean that if, as with the Hyman Act, an injunction is put into place against the hate monger. So if you go to court and succeed in getting an injunction against the hate monger is then subject to this court order, and if they breach it, they could then be criminally charged with breaching the injunction. And the focus in any such criminal trial, it wouldn't be on the speech itself, it would be on whether or not the individual breached the court order. That would be the focus of the trial. And so an injunction can actually offer sometimes a quicker and even arguably more effective path into the criminal law. And there's actually historical and legal precedent for this. Some of you may be familiar with a man named John Ross Taylor, who was a neo-Nazi, really a Nazi, not just a neo-Nazi. He was active during the 1970s and even before World War II. And John Ross Taylor was charged ultimately not with hate speech. He was charged with violating a cease and desist order that he had been subject to by a human rights tribunal. Now, ultimately, his conviction was upheld. So another factor that we may want to keep in mind is the definition of hate speech in a criminal or human rights proceeding is extremely narrow. Hate speech has been defined very, very narrowly so as not to infringe freedom of speech. It's usually described in a criminal proceeding as an unusually strong and deeply felt emotion of detestation or vilification. So it covers only a very narrow ground of speech. Now, all of this is not to argue that civil lawsuits are free of impediments, but simply that they might provide a resource to supplement our focus on the criminal law. And we should, of course, always consider non-legal approaches, including Holocaust education, racism, anti-xenophobia education that may be more effective than the ex post facto nature of a legal proceeding. So there's really no shortage of things to discuss here further, but in the interest of time, I want to leave it there. I just want to, before I close, again, thank sincerely the Jewish Heritage Center of Western Canada for promoting my work and for their invaluable research assistance. It's really a fabulous, fabulous organization. And as you may have noticed, I relied on many of their archival documents here today and in my paper. And thank you as well to the Jewish Federation of Winnipeg, the Switzer family, and to all of you for coming today. Feel free to reach out to me by email or on social media, and I look forward to any questions you might have. Thank you very much.
Thank you very much, Kenneth, for that very illuminating paper, which touches, as as you noted, on contemporary issues as well as historical issues. That's always very important for an historian to see what conclusions can be drawn, or how the past informs the present and helps shape the future for good or not. This question from Corey Sheffman. Do you think these provisions of the Defamation Act are constitutional? Why and why not? What's the constitutionality of it?
Sure. So, hi, Corey. Thank you very much for the question. It's a great question. So, let me answer it in a couple of ways. Well, let me start by saying, yes, I do think it's constitutional. And I think there's a couple things to keep in mind, and hopefully I'm not getting too far into the legal weeds. But there's one question, which is a matter of the Charter of Rights and Freedoms. So the Charter of Rights and Freedoms, as many of you likely know, sets out certain guarantees. And one of those guarantees is freedom of speech or freedom of expression under Section 2B. That is the provision that really came to the fore in Zundel, Keekstra. We've also seen it in more recent cases, of course. And I certainly do think this would be upheld as a matter of freedom of expression. I think not only the Keekstra case, but I think much of the Supreme Court's recent case law on this issue has, I think, really shown a much more sensitive appreciation for the feelings of minorities. And keep in mind that although the common law rule is that these types of lawsuits are prohibited, I don't think there's any question that the common law rule can be amended by statutes. And in so doing, for the reasons I've mentioned, I don't think it would contravene the Charter. Now, there's a second question here in terms of constitutionality. There's a sort of an interesting legal issue that's embedded here about division of powers. And I'll try to be brief so all of you don't fall asleep while I explain this. But essentially, the federal government and provincial government each have their own sphere of authority. And the federal government has the authority to enact criminal legislation. Only the federal government may enact criminal legislation. There has been some indication in the case law, the limited case law on this provision, that this extra line that was added, that the speech must tend to raise unrest or disorder among the people, that additional line might make the provision into criminal legislation and therefore outside the scope of authority of the provincial government. That has been questioned in the jurisprudence. I don't think it is a particular concern for a couple of reasons. The primary reason is actually, I sort of mentioned in passing that the legislation was amended. I believe the amendment was in 2002. And in addition to adding sexual orientation, something else that was amended in the legislation was a provision specifically inserted to make clear that the provision should not be construed to essentially infringe or intrude on any authority under the Criminal Code of Canada. So it's sort of the legislature's way of saying, hey, courts, you should interpret this in a way that makes sure that we're not doing anything we're not allowed to do. We're not intruding on the federal government's criminal law power. So because of that, I think that the law remains on the right side of the line. And I would just add on that topic that this line tending to raise unrest or disorder among the people, this extra requirement, it imposes an extra requirement that it is sensible in light of the history, because Marcus Hyman really thought it was necessary to insert to get the unanimous support of the legislature at the time. But I don't think it's necessary to accomplish the object of the provision. In fact, I think if it was deleted, the provision would be stronger, because essentially it would remove an obstacle. So in addition to essentially alleviating any division of powers concerns, it would also make the legislation stronger, while for the reasons I've already mentioned, I believe not contravening Section 2B. So I'm definitely of respect to anyone who has an opposing view, but that's sort of my view on the constitutionality.
Thank you. There's I think I'll let Mr. Sheffin follow this up by asking, do you have any thoughts on why these provisions have not been used more often?
Yeah, it's a great question. I have thoughts on it. I'm not sure. These thoughts are a bit speculative, and you probably have a few in mind as well. I think one reason perhaps is simply that the criminal legislation has kind of sort of sucked up all the oxygen in this area. I mean, the natural reflex, particularly since 1970, I think in this type of situation has been to charge someone criminally. And while I made an argument in favor of civil law remedies, it should be noted, and some of you may have thought of this as well, that there are advantages to criminal law remedies too, and a primary advantage is that it is the state that is undertaking the prosecution rather than the individual, right? So the Hyman Act and similar legislation, it puts the onus on the individual. So I think that's maybe one reason why the criminal law is often turned to reflexively, because simply in these situations, I think our natural impulse is to go to the police or to seek help from the authorities. And sometimes a criminal prosecution results and sometimes it doesn't. Another reason is that I think this kind of statute has been somewhat forgotten. It exists only in Manitoba. And the Supreme Court has said quite clearly there have been attempts to bring similar lawsuits in other provinces, just not in Manitoba, but they have bumped up against this common law prohibition that you cannot bring a group defamation claim. So the leading case on this, it's called Boo Malhub. Boo Malhub, it's a case out of Quebec where someone tried to circumvent this rule. I believe there it was Islamophobic speech that had been made by a radio commentator. And someone tried to bring a lawsuit on behalf of the offended group. And they tried to circumvent this rule by making it a class action lawsuit. And it went up to the Supreme Court, and the Supreme Court said, you cannot do this. Absent a legislative amendment, you cannot do this. It's prohibited. You cannot have a group defamation lawsuit. So that could be another reason, simply that it has been tried elsewhere, but the Supreme Court has seemingly put a stop to it. And so we're left with this sort of statute in Manitoba, which seems to be somewhat forgotten. Anyway, just a couple theories. I'm sure probably the people assembled here can think of other reasons, but that's just what comes to mind.
Thank you. There's a question from the account of Fred Switzer. Is there any comparable law in the United States? Let me add Great Britain to that, UK.
That's a great question. Also, my understanding is there is not. It is a general common law rule that applies, to my knowledge, in all common law jurisdictions. I'm not aware of it being amended by legislation in any common law jurisdiction, which is not to say it hasn't been, but I'm just not aware of it. I do know that in the US, as you likely know, there is no criminal legislation against hate speech because of the First Amendment. And there have been some recent lawsuits under statutes combating people, for example, the organizers of the Charlottesville rally, that dealt with sort of somewhat similar conduct, but they're not strictly speaking group defamation statutes because they require some measure of physical harm. So that's a long way of answering. I'm not aware of any, and it is a general common law rule that applies across all common law jurisdictions, to my knowledge.
Thank you. And Paul Switzer asks whether Whittaker had any links to Henry Ford's anti-Semitic Dearborn Independent.
That's a great question. Unfortunately, I don't know the answer. I'm sure he was an avid reader, but I don't know if he had any direct links to that movement.
Let me ask a question then. If the Hyman Act was used against a newspaper. Now, perhaps the principal form of hate speech these days is social media. which I take it would be harder to pin down. Is there any use to the Hyman Act against social media activities?
Professor Stone, that's a great question, and it's a really good one. And I think the short answer is yes. I do think the Hyman Act can have some utility even in the social media space. One reason is because often criminal code charges are contemplated against people on social media, but for some of the reasons mentioned, the criminal proceedings have proved difficult to implement and somewhat ineffective. Now, problems of sort of anonymity on the internet, they affect the criminal and the civil law somewhat equally. So both the civil law and the criminal law are going to encounter some problems when it comes to social media, but certainly if we're using the problem of social media, I think speaks to the need for as many resources as we can have at our disposal. And I think the criminal law has proved particularly challenging to use in an era of social media proliferation. So a civil lawsuit certainly could be launched against someone promoting hatred on social media. Another thing to keep in mind is that the criminal law really has no or very little extraterritorial application, right? So someone might be located not in Canada, but somewhere else. And if this type of lawsuit is permitted, perhaps in other jurisdictions, including in the United States, again, that would sort of broaden the reach of this type of remedy and perhaps do a little bit of help to overcome this type of this problem with extraterritoriality, this problem that really the criminal law cannot apply across the border. So it's a couple of reasons why we need more tools at our disposal, not less. This tool can be easier to use, and that applies equally to social media legislation. Now, social media, it's in the spirit of more tools, not less. There's a whole separate topic, of course, of social media regulation and the advocacy of that. And that's something that the government has considered and then pulled back from, and now maybe seems to be considering again. And there's a private members bill that was recently introduced by the NDP to essentially force social media companies to be more transparent about their algorithms. That's a whole separate sort of kettle of fish, and I'm not sure how effective it would be. But the problem with social media really, it exists across all of these mechanisms, and the more mechanisms we can have at our disposal, I think the better off we'll be, in addition, of course, to non-legal approaches.
Thank you. Now, Corey Sheffman has another follow-up question, but I'm going to go to someone who hasn't asked one yet, which is Beljanevsky. Could the act be used against the proliferation of anti-Semitic hate literature that we're seeing from the so-called Goyim Defense League?
Yes, absolutely. I mean, I don't see why not, other than just keeping in mind that the act is limited to Manitoba, and it would be helpful to have similar legislation elsewhere to broaden the reach of this type of legislation. But absolutely, I mean, I don't see why not. I mean, it applies to written libel that affects a particular group, and it seems fairly clear that given the conduct of organizations like the Goyim Defense League, that one would hope that you could obtain an injunction. Certainly, I think given their conduct, the brazen nature of their conduct, you could meet this requirement of tending to raise unrest or disorder. It's certainly libelous. And so I would think it would be possible to obtain an injunction. Sure, I don't see why not.
Corey Sheffman picks up the thread once again. When the legislation was passed, institutional anti-Semitism was still very prominent in Manitoba, with restrictions on Lake Winnipeg beaches, buying property in certain neighborhoods, and quotas at the University of Manitoba Medical School. Did the media at that time reconcile the support for the Hyman Act with the anti-Semitism that was otherwise still pretty pervasive? Does it just come down to Hyman's own respectability?
Thanks, Corey. It's a really, really good question. I think, look, as far as I've seen, I did quite broad media searches for this, but obviously there's a lot I didn't read in terms of media coverage. But I didn't see in the coverage of the Hyman Act any sort of reconciliation of this with the other institutional racism at the time, and I think that's simply for the reason that, you know, as sad as maybe it is to say, they probably didn't recognize institutional racism as racism, right? At the time, there wasn't the same appreciation we would have now, and even post World War II, for the insidious nature of this type of institutional racism. So I think the focus of the Winnipeg media, or the Manitoba media more broadly, as far as I can tell, was specifically on fascism. Institutional racism, I think, for them was largely okay. I think it was taken for granted, for, you know, which is not to condone it, but I think that's just the way things were, unfortunately. But to the credit of the media, they did seem to draw a strong line when it came to fascism. And as others here, I'm sure, know, there's some experts in Manitoba history who know more about this than I do, but I do know that the Winnipeg Free Press and its editor did, from basically day one of Hitler's rise in Germany, take a very strong stance against fascism. And I think that influenced their, so I think it wasn't just Hyman's reputation. I think it was also the fact that the environment in relation to fascism, if not anti-Semitism more broadly, was less favorable to fascism in Manitoba than it was elsewhere. And the media seemed somewhat unanimous in that view, at least the major media that I've seen in Manitoba, which I think largely influenced them supporting the Hyman Act. I think another factor that may be relevant, which I didn't have time to get into in the presentation, but I do explore a bit in the article, is Whitaker, for all his faults, should not be considered the brightest of lights. And one of the things that he did was he really attacked the government directly. He sort of dared the government to do something. And the government did something. And I think that's part of the reason as well why Hyman was able to garner unanimous support, because Whitaker was sort of doing these outrageous things, creating an atmosphere of violence, and essentially daring the legislature to stop him. And so that's something else to keep in mind. But in terms of institutional racism, I think that was something that was just sort of taken for granted back then.
Thank you, and thank you, Corey Sheffman, for these illuminating questions and for the other questions. I think there are none more submitted. I'm just going to give you a little anecdote about the Canadian Nationalist Party. Quite a few years ago, a friend of mine came to me and said that her relative had bought a secondhand table. It was one of these tables, pedestal tables with a big, it come one single leg in the center, and it's spread out in order to support the table in a wide sphere. And in refinishing it, the person took the tabletop off and found a treasure trove, if you want to call it, of Canadian nationalist literature.
Oh, wow.
That had been hidden there by some Canadian nationalist at some point, possibly at the start of World War II, possibly earlier. But there are probably some very interesting materials around that are hidden in table legs or attics or who knows where.
Professor Shum, was this Connie Warwick? Was this person Connie Warwick?
Oh, yes.
I've spoken to Connie, and I acknowledged her in my article. She was actually very, very helpful. She did share some of her materials with me.
I've lost touch with her. I'm happy. You can tell me where to find her.
Okay, I will. I'm glad at least I have the opportunity on the recording to thank her as well, because she she did actually provide me with some of her material as well, which was very, very helpful to me.
There's a question from Bruce Ryder, but I don't see the question. If Bruce Ryder would put it in a form that I can relay it, or that Kenneth can see himself, that will help.
I can check the Q&A.
Oh, I
Oh, I think I
didn't pull it
think
all
I
the
see.
way
Oh,
down.
I see it.
Thank you. I missed a couple because I didn't scroll down far enough.
Sorry,
I'll
Professor.
read it.
Okay,
Bruce
go ahead.
Ryder, thanks so much, Ken, for the excellent paper. Great to learn about this legislation and the Tobias case. I've been studying an example of early legislative action against anti-Semitism in Ontario, the 1932 amendment to the Insurance Act prohibiting discrimination on the basis of race and religion by the insurance industry. The only prosecution under the act led to an acquittal of the company that had engaged in widespread anti-Jewish practices. That legislation failed to achieve its objectives in the 1930s. Do you think that there was a difference in the nature and degree of anti-Semitism in Toronto compared to Winnipeg at that time that might explain the differences in the success of the two laws?
Thank you, Professor Ryder, for attending, and thank you for the excellent question and the remarks on my paper. Thank you. It means a lot. It's a great question. I've seen a bit of your work, your fantastic work, and to answer your question, yes, I absolutely do think there was a difference in the nature and degree of anti-Semitism between Toronto and Winnipeg at that time. And certainly that difference might explain the difference in success of these two laws. I just think why this was the case is not 100% clear, but it's been suggested that there was sort of a larger immigrant community more broadly in Manitoba, and specifically Winnipeg at the time, and as compared with Toronto at the time, which, as you of course know, was quite a homogenous community. And it seems like, as far as I can tell, pre-war fascism was really greeted with somewhat of an indifference in Ontario compared to Manitoba. And certainly institutional racism, although as Corey pointed out, not by any means absent in Manitoba at the time, I think was quite stronger in Ontario. And we only need to think about, as I'm sure you're familiar with as well, Professor Gerard's excellent work on Maura Laskin, our former Chief Justice, who had difficulty obtaining employment as a lawyer, even though he had done so well in law school. He couldn't get a job in the 1930s as a lawyer. And it seems like the situation in Winnipeg was much different. You have people like Marcus Hyman, William Tobias becoming prominent lawyers, very successful in the community, very well respected, right? When Marcus Hyman passed away, he had a state funeral, essentially. The mayor of Winnipeg was there, the premier was there. So I think it's just a totally different climate. And you see that in the media as well, between Toronto and Winnipeg. And certainly with respect, I mentioned briefly a similar legislative endeavor in Ontario as the Hyman Act, that actually in 1937, so after the Hyman Act was introduced and after the Tobias lawsuits, Ontario tried to introduce very similar legislation. A Jewish member of the provincial parliament, J.J. Glass, I believe was his name. And it really failed quite miserably. It didn't garner any support. I believe it faced a backlash in the media. And so the reaction was completely different. And it was a backlash, and there was outrage that someone would even suggest that you should infringe freedom of speech in this way. There was certainly no taking into account the fact that we might protect victim communities from this type of speech, which, as opposed to Winnipeg, as you see through the history of the Hyman Act, you see again and again, you see judges, you see politicians, you see editorialists saying, no, this is unacceptable. So Yes, absolutely. I think it's a much different climate in Winnipeg than in Toronto at that time. And absolutely, I think that can help explain the difference in success between those two laws, just as it explains the difference in success of the two sort of group defamation laws that I mentioned, the one in Ontario that failed and the one in Manitoba that succeeded. But thank you very much for the question.
And a question from Murray Trachtenberg. The Zundel and Keeksford prosecutions showed that an unintended consequence of prosecution was to give them and their ideology greater exposure than they would have normally had. Do you have any thoughts as how an action that seeks actual damages from individuals could be brought?
Thank you very much, Marie. It's a great question. I'm wondering if I can do it justice. In terms of how they could be brought, well, again, keep in mind, only in Manitoba and only for an injunction, unless there's defamation of a specific individual. But I do think that now, if the provision would allow for damages, the problem with seeking damages is you can always obtain them, but you can't always get payment of them, which is not to say they can't be effective. I'm just thinking recently, someone like Alex Jones in the United States, the InfoWars guy who was sued for defamation, and there was a $1.4 billion judgment rendered against him. That's sort of an example of where, now that was individual defamation. It was defamation brought individually by parents of victims of a school shooting, and he had been saying the school shooting was made up. But they brought this lawsuit, they were successful, and they got a $1.4 billion damage award. As far as I know, they haven't been paid a cent, but Alex Jones has since declared bankruptcy. So not to say that there can't be any utility, but that's one example. But otherwise, as I said, like, I think there may be advantages to seeking the injunction rather than damages for the reasons that I've mentioned, which is that, in terms of exposure, it may provide for a quicker proceeding. You can get an interim injunction, maybe less exposure if you're not seeking damages. I think generally speaking, in a civil trial, in a tort law case, you're going to have less exposure than a criminal case. Criminal cases just by their very nature tend to have more exposure. So I hope somewhere in there I've answered your question, but that's how I think it would work in practice. And as I think Belle asked me earlier, I don't think there's any reason why, if you have someone, if the goal of the community is really to sort of shut these people up, which I think it often is, right? That's often the primary goal. Then I don't see any reason why you can't use this legislation to go to court and seek an injunction.
Thank you, Kenneth, and thank you, questioners. It's getting to be a long evening, so I will cut it off here. Thank everybody for this and for the lively discussion. And let's see, the computers are always interesting. So I thank you again for your very illuminating paper. And as he noted earlier, the anonymous academic jury that selected it for this year's winner. I thank the questioners and the audience and the Switzer family for setting up this prize that brought us numerous fine pieces of work to our attention since 2008. I thank the staff of the Jewish Heritage Center, Belzhanievsky, Stan Carbone, Andrew Morrison, for their work in organizing the competition. Last but not least, I thank Gustavo Zentner and the Jewish Federation of Winnipeg for its continuing support that allows the Heritage Center to carry on its twin mandate to document, preserve, and share information on the culture and historical formation of the Jewish communities in Western Canada, and to act as an advocate for anti-racism and education on the Holocaust and anti-Semitism. Now I'll turn the podium over to Belzhanievsky, the Executive Director of the Jewish Heritage Center, to wrap up. Bell is also the chair of the Holocaust Education Committee and a government-appointed representative on the International Holocaust Remembrance Alliance. She functions within the broader community through activity on the Multi-Faith Council and other institutions. Bell, tell us about what's coming up and anything else that you want to add, please.
Well, thank you so much to everyone. I add my thanks to yours, Dan. I also want to remind anyone that is online that this program was recorded and that we will be putting it up on our YouTube channel. So if you think that there's anyone who may be interested in watching, please let them know. We have some wonderful, wonderful programs coming up this autumn. The first one will be Monday, October 16th in the Burney Theater at 7 p.m. An evening of memories, Rosie Siskin Family, Community, and Politics. And the program is dedicated to commemorating the life and accomplishments of Rosie Siskin, of blessed memory, and a well-known social activist. And then in November, we have 4 programs for Holocaust Education Month. They are all on Sunday afternoons. The first one is on November 5th at 2 p.m. in the multipurpose room, where our own Dan Stone will present his extensive research on Holocaust commemoration in Winnipeg from the post-war period through 1980. On Sunday, November 12th at 2 p.m. at Westwood Collegiate, which is at 360 Rouge Road, we will be holding our community-wide Kristallnacht commemoration. And this will be a presentation of the film Reckonings by award-winning filmmaker Roberta Grossman, and it will recount the tense negotiations between Jewish and German leaders. It is being presented by the Jewish Heritage Center, the Jewish Federation of Winnipeg, and Jewish Child and Family Service, and of course, Westwood Collegiate. Then on September 19th, at 2 p.m., we will be presenting a very interesting film called The Cure for Hate in partnership with Westwood Collegiate and Peace Days 365. The film is about the former neo-Nazi, Tony McCallier. He was a skinhead and a Holocaust denier who has gone on to become a founding member of an anti-hate activist group. And we will be having Tony with us in person, as well as the producer of the film. And then finally, on Sunday, November 26th, back at the Burney Theater, again at 2 p.m., Professor Ralph Stern will be presenting 2 Streets and a Synagogue, Urban Encounters in Nazi Berlin. And this is based on Dr. Stern's extensive research. And that's it. I thank you all for your participation tonight. And thank you again, Kenneth, for your wonderful paper. And good night.